Good afternoon, everyone. You're very welcome to this, the first in our series of webinars focusing on the impact that the current COVID-19 crisis is having on the built environment generally. My name is Jamie Fitzmaurice. I'm a partner in our real estate department here in Mason Hayes and Curran, and today I'm joined by my colleagues Laura Farrell and Cullum Farrell. Laura is a senior associate in our real estate department and Cullum is a senior associate in our commercial litigation department. And today, Cullum and Laura are going to be talking to you about the impacts that the crisis is having on the residential sector, looking at how it's affecting residential landlords and residential tenants. For those of you who are interested, we do have a second webinar tomorrow focusing on the impacts that the crisis is having on commercial landlords and tenants, primarily in the retail environment, but also focusing on the hotel licensed premises sector as well. So the format for today is Cullum is going to speak to us first, followed by Laura. We'll then have some takeaways from Cullum at the end, and we should have 10 or 15 minutes for any Q&A that you might have. So we're trying to keep this as interactive as possible. So if you do have questions for our panelists, please do put them into the Q&A function in front of you on the panel, and we'll try to get to as many of those as we can at the end. So without further ado, I'll pass you over to Cullum Farrell. Thank you.
Thank you, Jamie. Good afternoon, everyone, and welcome to my kitchen. Unless you've had your head very much buried in the sand the last number of weeks, you'll know that the only thing that's really making the headlines at the moment is COVID-19 and how it seems to be affecting all areas of life and business, to include the landlord and tenant sector, both residential and commercial. Jamie, you might just move on to the next slide, and again, please. So for those of us, and go back. Sorry, for those of us who work in this particular area, you'll be familiar that there was amending legislation introduced last summer that revised termination notice requirements and termination dates, etc. But we really didn't expect to see a new piece of legislation in this particular area of law so quickly. But it is very much a case of we now are where we are. So what have we been seeing in real terms in the last number of weeks is requests from tenants looking for rent holidays or rent reductions. And on the landlord side, we've seen landlords being proactive in engaging with their tenants early to try and make sure that it's business as normal insofar as is possible and to keep the rent coming in. So moving on to the next slide, Jamie. So the piece of legislation we're going to discuss today is the Emergency Measures in the Public Interest COVID-19 Act 2020. Now this is a piece of legislation that deals with a number of areas of law, but insofar as it's relevant to today, I've highlighted the section there in red from the long title of the Act. So effectively it says it's an amendment to the Residential Tenancies Act 2004 during the period of 3 months. This is a piece of legislation that was circulated in draft on a Tuesday night. The bill was then discussed and debated in the Dáil on the Thursday for a number of hours until late in the evening, with a number of sections being introduced late on the Thursday night, which are somewhat unhelpful and in part contradictory, and we'll discuss those as we go on. The bill was then debated in the Seanad on the Friday and ultimately signed into law by the President on the Friday evening. So there you can see that the timetable was very quick in terms of drafting, debating and introducing the legislation. Now, while the sections that deal with the residential sector are relatively short, their impact is far reaching and we'll go through those. So just moving on to the next slide, Jamie. So what does the Act mean for tenant or for landlords in real terms? The Act imposes a number of prohibitions on landlords, and we're going to touch the three main ones are that during the emergency period, a landlord cannot issue a notice of termination. Secondly, that during the emergency period, a landlord cannot evict tenants. And thirdly, that during the emergency period, a landlord cannot implement rent increases. Now, these three key points have got a lot of media attention and were the subject of the headlines in one of my former slides. However, what hasn't got much media attention or much comment at all is that during this emergency period, tenants are still obliged to pay their rent in accordance with their lease. Indeed, tenants are obliged to comply with all of their tenancy obligations during this emergency period, and that should not be forgotten. So just moving on to the next slide, Jamie. So I mentioned in the last slide the emergency period, and what does that actually mean? This is a defined period set out in the legislation as being 3 months commencing on the 27th of March. However, there is ability in the legislation for this 3-month period to be extended in the public interest. And I suppose if we know anything from what has happened in the last number of weeks, is that dates that are being imposed by the government are, it seems, somewhat of a movable feast. And while there definitely is light at the end of the tunnel in that this will come to an end at some stage, it's not beyond comprehension that this 3-month initial period might be extended somewhat. Moving on again, Jamie. So as I said, the first prohibition under the legislation is that landlords cannot serve notices of termination during the emergency period. So the question then becomes, what of notices of termination that were served prior to 27 March, but that are due to expire during or after the emergency period? And what will happen in those cases is that the original termination date will be revised and replaced with the revised termination date. And the revised termination date is the length of the emergency period and the time that is left to run on the notice of termination as at 27 March. So if we take a practical example, if a landlord has served a notice of termination giving 196 days, for example, and as at 27 March, there was 100 days left to run on that notice, there will still be 100 days left to run on that notice at the end of the emergency period. So in practical terms, what does the landlord need to do in respect of notices that have been served? Clearly, you should engage with your tenants and confirm to them that the emergency period or the emergency legislation is enacted and that the termination date is going to be revised. However, we would suggest that at this time, it is not prudent to confirm what the revised termination date is going to be because we don't know definitively how long the emergency period is going to last for. Just moving on to the next slide again, Jamie. So the second key point is on evictions. Evictions is a concept and a term that's not defined within the legislation, but it's very clear what is intended in the legislation is that no one will be dispossessed of their homes during this emergency period. And that's the general rule, that there's to be no evictions during the emergency period. However, there are some exceptions to this. And in the main, it is where a landlord has a determination order or on appeal a tribunal order of the RTB that requires the tenant to vacate the property. In those circumstances, the tenant should vacate the property and the landlord is entitled to possession. In practical terms, as you may be aware, where a tenant fails to comply with a determination order or a tribunal order which requires them to vacate, the next step for the landlord is that he will go down to the district court and seek an order from the district court, which can then be enforced in the ordinary way. However, at the moment, the work of the courts is largely focused on urgent matters, and I don't think that an application such as this would be deemed urgent in the circumstances. So while there is an exception there, practically speaking, it may be that you will have to wait until after the emergency period and everything is back to normal before you can take the enforcement step. So just moving on to the next slide again, Jamie. As I said a while ago, the legislation was introduced quite quickly and in some respects could be considered to have been rushed, and it has some contradictory sections and maybe it has some unintended consequences. You'll see there in front of you section 5.7a, which provides, notwithstanding any of the provisions in this section, all proposed evictions and tenancies in the state, including those not covered by the Act of 2004, are prohibited during the operation of the Emergency Measures in the Public Interest COVID-19 Act. So the long title of the Act makes it very clear that it applies to the 2004 Act, which covers landlord and tenant in the residential sector. But this particular provision seems to be broader than that. Since the introduction of the legislation, the RTB have introduced some guidelines and they've made clear that the intention of this particular provision is that it would relate to those lesser formal arrangements of landlord and tenant, for example, digs. However, on a straight and formal, strict reading of this particular section, it could also be said to apply to commercial tenancies. And this is something that's going to be discussed by my colleagues in tomorrow's our webinar. So just moving on to the next slide and passing you over to Laura.
Thank you, Colin. I'm now going to talk to you about the other main arm of the legislation, and that's what it says about rent. Now, when Colin was talking to you about tenancy terminations and evictions, there are numerous sections in the legislation that deal with that, but there's only this one section, which is section 6 there on the slide, that deals with rent. And section 6 says that no rent review can take effect, no increase in rent can take effect during the emergency period, and neither can any increase in rent be payable during the emergency period. But it doesn't say anything more and leaves us to do the work of unpacking what this actually means. So next slide, Jamie, please. I've listed there a few questions to guide us through the operation of the section. So we know that the rent increase can't take effect during the emergency period, but when does it take effect? Well, the rent increase will take effect on the first day after the end of the emergency period, or the date that is stated in your rent review notice for the new rent to have effect, whichever of those two dates is the later. The next question there is, when can a tenant bring an application to the RTB in relation to a rent review notice? And the answer is that that is entirely unaffected by the new legislation. And so it might very well be that a tenant's time to bring an application to the RTB in respect of a rent review notice will expire during the emergency period, even though there's no way for the rent increase to take effect during the emergency period. Possibly the most important question on this slide is the question written there, which is, when we are assessing the market rent, are we concerned with the market rent at the date the notice was served, or are we concerned with the market rent at the date the new rent is to come into effect? Now, bearing in mind that rents might change and might reduce quite rapidly now, this will be an important question. We are quite comfortable that the Residential Tenancies Acts are clear that you assess the market rent at the date the new rent is set. So that's either before or at the time you serve your notice of rent review. And this means that if you say, for example, served your rent review notice back in February, and if hypothetically the emergency period only ends in August, and again, hypothetically, the market rent is appreciably lower in August than it was in February, this will not matter, and your rent review notice won't fail a market rent test on that basis, because the important date for assessing market rent is the date the new rent was set. Now, this brings us on nicely to the next question there on the slide, which is, can a rent review notice be served during the emergency period? And the answer to that is yes, it can. The prohibition is on the rent increase taking effect. So if you are allowed to serve a notice of rent review now according to your own normal schedule of service of rent review notices, and if you can find sufficient evidence of the market rent in the last 4 weeks, it might be a good idea to serve a notice of rent increase now. And even though you're ultimately the rent won't come into effect until after the end of the emergency period, on the basis that the market rents potentially might be higher now than they are later on down the line at the end of the emergency period. Next slide, Jamie, please. So this brings us on to the question of rent decreases. And we are aware of lots of tenants that have been making approaches to their landlords for decreases in rent, and also that landlords have been amenable to these requests. There's absolutely no obligation on a landlord to agree to such a request. And if a landlord chooses to agree to a request to decrease the rent, there are numerous ways that the landlord might choose to structure this. The landlord might allow the deposit to be used up for rent. The landlord might allow a rent deferral that the landlord understands is never going to be called in. Or the landlord might, in a more straightforward way, agree that for a given period of time, because of the tenant's temporary financial difficulties caused by the COVID crisis, that a lower amount will be accepted by the landlord in full discharge of the rent owing under the lease. Now, if this last option is taken by the landlord, and we think it can be taken by a landlord and taken by a landlord safely, the landlord needs to be very careful about how that agreement is recorded. We would suggest that that agreement is recorded in writing, and in simple terms, use plain English to set out exactly what's happening. This isn't a review of the rent. It is simply a temporary concession. The rent remains at the level that was set out in the lease, but for a short defined period of time, the landlord is going to accept a lower amount in full discharge of the rent that is in fact owing. And I've emphasized recording that carefully because, of course, what as a landlord you don't want to happen is you don't want down the line the tenant to be able to say, well, the reduced rent is now my rent from which the 4% calculation will take place. And similarly, you don't want to be prevented from carrying out a review down the line by the tenant saying, well, it's too soon for a review to happen because of that review that happened during the COVID period. The next question there I've written is, can a decrease be demanded by the tenant? Now, of course, what Colm said is absolutely right. The rent obligation on the tenant's obligation to pay the rent remains and is totally unchanged. But there is a provision in the Residential Tenancies Acts that's been little used and might be more used. And that's a provision that allows a tenant to demand, or actually the word used in the legislation is require, that allows the tenant to require a review of the rent. Before a tenant can do that, it must be time for a review according to the schedule of reviews for that tenancy. And also there can't be a provision for a review in whatever written lease or tenancy arrangement is in place between the landlord and the tenant. But otherwise the tenant can require a review, and that will be a market rent review. So if the rent is, if market rents are lower, the rent will go down. And we might see, subject to what happens to market rents, tenants requiring rent reviews. Next slide, Jamie, please. So now this heading here, some things never change. So this is really a list of miscellaneous points I wanted to make about important matters for residential tenancies that are not affected by the new legislation. So the first point there is acquisition of Part 4 rights. So if you are a landlord and you have a tenant in a dwelling and you had wanted to take advantage of the opportunity afforded to you by the Residential Tenancies Acts to terminate that tenancy in the first 6 months without giving one of those reasons that are contained in section 34 of the Act, do not worry, you will not lose that right to serve that type of notice by virtue of the emergency period. If your tenant went into the emergency period in month 5 of their tenancy, they will come out of the emergency period in month 5 of their tenancy, and you will still be able to serve that notice that's reserved to the first 6 months of a tenancy. I suppose allied to this is a question that we might all confuse ourselves with down the line, and that's when you are calculating the duration of a tenancy to work out how much notice you need to give in your notice of termination, do you count in the emergency period to that calculation? The RTB in their guidance notes have used language of the tenancy being paused. And we think there's a good argument based on the legislation that you don't need to include the emergency period when you're counting the duration of your tenancy. But prudence would probably suggest that you would count it in and avoid any issue down the line that your notice of termination would be invalid for having given insufficient notice of termination. The next point there that's unchanged is the treatment of antisocial behaviour. There is no carve out in the new legislation for antisocial behaviour, even very serious antisocial behaviour. So if your tenant is acting in a way that is antisocial, you cannot serve a notice of termination. If it was exceptionally serious antisocial behaviour, you might need to go down the route of asking the RTB to apply on your behalf to court for an injunction in relation to that tenant, but that would have to be profoundly serious antisocial behaviour. And what's advocated by the RTB in their guidance notes is that landlords would engage with tenants and would talk as a means to resolving situations. Now, the third point there on the slide is a tenant serving a notice of termination, and that is also entirely unaffected. So a tenant can terminate their tenancy during the emergency period and would need to just follow the normal rules. So they serve a valid notice giving the requisite notice period. If the tenant wants to terminate during a fixed term, then the tenant can only do that if the landlord's in breach of obligation and the tenant has given the landlord notice of that breach and the landlord hasn't remedied that defect, or except in the case of student accommodation, the tenant has asked the landlord if the tenant can assign or sublet, and the tenant has refused that permission. But they're just the normal rules, that they're not changed at all. And the final thing listed there that hasn't changed are the landlord's and the tenant's other obligations. So the landlord carries the landlord's normal obligations in relation to repair and maintenance. Now, that might become very difficult because of the requirements on social distancing, and it might be difficult to have repairs done, but the landlord must act reasonably and do what it reasonably can to comply with the obligations under the Act. But all obligations other than those expressly affected by the new legislation remain the same. Next slide, Jamie, please. And just finally, I wanted to talk about accommodation for frontline healthcare workers. So we've heard media reports of certain accommodation providers giving accommodation to frontline healthcare workers, to the HSE, and without charging for that. And the question arises as to whether this can take place, and if it does, is it impacted by the Residential Tenancies Acts? And our view is that these types of arrangements can take place outside the context of the Residential Tenancies Acts if the arrangement that is put in place is a licence. The Residential Tenancies Act, except insofar as it applies to student accommodation, which is something different, applies to tenancies. So if what is actually agreed with the HSE or with the individual healthcare worker is in fact a licence, then the Residential Tenancies Act won't apply to that arrangement. Next slide, Jamie, please. So thank you for listening. I'm going to pass you back now to Colin, who's going to speak through these key takeaways.
Thanks, Laura. So just again to run through I suppose the main takeaways from today's talk, and what is prohibited by a landlord is that rent is still payable unless there's a separate agreement with the landlord, and that needs to be communicated to tenants. Notices of termination cannot be served during the emergency period. Revised termination dates will apply to existing notices where they're due to expire during or after the emergency period. There's a freeze on rent increases, and with the exceptions, there's a halt on evictions. So they're the three key takeaways, or the key takeaways, and then there's the other ancillary issues that Laura discussed as well. So happy to take any questions that you may have.
Colin, Laura, thank you very much. I think you've given us a lot to think about there, and that's evidenced by the questions which have come in. I've been going through them during your talks, and there's a couple of common themes amongst the questions, so I'll try to paraphrase them and lump them together as best I can. First question for Laura, and I think this is probably stemming from the recent obligation on a landlord to register with the RTB any rent reviews. So if a rent reduction is agreed, Laura, is there and entered into with a tenant in writing, as you'd suggested, is there an obligation on the landlord to register that rent reduction or abatement with the RTB?
No, we don't think so, and on the basis that it's not actually a reduction of the rent as such, but a temporary concession, and we don't think there's any need. No.
Okay, thank you. And I think, Laura, you've clearly struck a chord with your warning there. Are there no circumstances during the emergency period, Laura, where a landlord can evict the tenant for social behaviour?
You can't serve a notice of termination during the emergency period. That's categorical in the legislation. So
I suppose just teasing that through, like even if you had a tenant with not insignificant rental arrears coupled with antisocial behaviour, you are, for the course of the emergency period, from a landlord's perspective at least, somewhat snookered.
You probably are somewhat snookered. I mean, the RTB won't want to be hearing about you in respect to those rent arrears, but if there was exceptionally serious antisocial behaviour, it would be open to you, as it's always open to a landlord if the normal rules aren't sufficient, to go to the RTB and ask the RTB to apply on that landlord's behalf to a court for an injunction. But short of that, which would have to be reserved for the most serious cases, no, you can't serve a notice of termination during the emergency period.
Presumably, Laura, coupled with that is given the restrictions with which the courts are working at the moment, it would want to be very serious to try and, I suppose, evict somebody into a COVID-19 crisis.
Absolutely, and you'd be asking the court to allow something that had been forbidden by legislation, so it would need to be profoundly serious.
Okay, thank you. Colm, I suppose an important point really, is there a positive obligation on a landlord compelling them to reduce rent or otherwise act reasonably with their tenants?
So I suppose the relationship between the landlord and tenant first and foremost is governed by the lease, and that's the contract that's in place here. So unless the landlord decides voluntarily or at the request of the tenant to facilitate the tenant and grant a reduction, there is no obligation in the legislation to do so.
Presumably, just thinking out loud myself, Colm, on that, presumably if you end up before the courts as a result of this, the courts will probably look to see whether you have acted reasonably yourself, or whether the parties themselves have acted reasonably in the current climate as well.
So I think here, if you were looking at rent reduction, obviously your first port of call if the tenant is in arrears of rent or if the tenant is paying less rent than he or she ought to, the first place you'd be going is the RTB, and you'd have very limited recourse to the courts. But I think the RTB will expect you to act reasonably, but that said, if you haven't agreed a reduction, then the rent as per the lease will stand, and that's the tenant's obligation.
Thanks. And then Colm, you mentioned...
If I could just put a point in there as well,
yeah.
I think part of this reasonableness might come in as well, in that if after the arrears have arisen, you then want to terminate based on those arrears, you're going to need to, at that stage, serve a warning letter before you proceed to serve ultimately your notice of termination. And that warning letter needs to give the tenant a reasonable time to pay those arrears. And in that context, certainly, that there was no reduction of the rent during the COVID time, and the tenant's ability to pay, certainly those requirements of reasonableness would come in there in that context.
Thanks. Colm, you mentioned that there's a discrepancy in the wording of the Act in terms of how it applies to tenancies versus residential tenancies. And I know the guys tomorrow will be touching on it in a little bit more detail on their webinar, but is it a question of getting more comfortable, or the market's getting more comfortable that it doesn't apply to commercial tenancies, or is it still a question of we don't really know yet, but it shouldn't?
I suppose our view is that it's more the latter than the former. So all of the indicators are that it shouldn't apply to commercial tenancies. So if you look at, for example, the long title of the Act, which we discussed at the outset, if you look at the explanatory memorandum that issued around the time of the Act's introduction, and if you look at the guidelines and Q&A that the RTB have issued, it all focuses on dwellings and houses in the private sector as it's understood. However, that said, as matters stand, it is unclear in the legislation. So I think any commercial landlord and tenant coming to this would have to have pause for thought in relation to that particular section before they would look to evict any commercial tenant. I think you would need to look at the picture overall there.
Thanks. Laura, where a tenant is exercising a break, does the emergency period get added to the break notice period, and what rent is payable?
We're imagining a scenario where a tenant in their lease has an ability to terminate the lease without notice, or what?
It's not really. I'm assuming the tenant is just terminating the tenancy having given the requisite notice.
Yeah, well, so the tenant's termination is totally unaffected by the legislation. So that will depend upon the terms of the lease. If the lease is being more generous to the tenant than the Residential Tenancies Act is. So I don't know the specific provision that questioner has in mind, but even if that particular lease posed something very generous to the tenant, like saying the tenant can terminate on 24 hours notice or something, that would be a valid term in a lease, and it would still be valid now during the emergency period.
Okay. Do either of you know, are RTB adjudications on hold during the emergency period? Sure, which of you want to take that one?
So I had an RTB adjudication that was listed here and just after this all kicked off, and we were notified by the RTB that it's adjourned, but we haven't been notified what that adjourned date is at the moment. So as I understand it, as I said, sort of the administrative work of the RTB is going ahead, but hearings at the moment aren't, so I'm just waiting for an update in relation to that. I know that the RTB was promoting sort of phone mediation in lieu of adjudication, but that has, I suppose, advantages and disadvantages as well, depending on the case in question and the nature of the parties involved.
Thanks. So I'm conscious that we're coming up towards the end of our allocated time, but there's one more question. I think I might just put this to you, Laura, if I can. Is there a risk to landlords in agreeing to reduce, defer, suspend, abate their rent? Is there a risk that that will go against them on a rent review once the emergency provisions are lifted?
Yeah, I think that's certainly something that a landlord needs to be aware of and needs to guard against. And that's why we would suggest structuring whatever happens clearly and also recording what happens carefully, so that the recording of that agreement makes very clear that this is not a rent review, this is not a rent reduction, and that at the time of the next rent review, you could even stipulate when that will take place according to your normal schedule of rent review. The rent will be reviewed from the rent under the lease, which is of course the higher rent.
Okay. Colm, Laura, thanks very much. That was very informative. I think we'll wrap it up there. Thanks very much to everybody who joined in and watched today. Thanks for your questions. Hopefully we got to most of those. Our events team will be following up after this with both links to this webinar together with slides. And do feel free to contact either Colm or Laura directly if you have any comments or questions. There'll also be a link to a survey. If you would take the time, please, to fill out that survey and let us know whether let us know what you thought of the webinar, obviously, but also let us know whether there are any other topics you'd like us to cover. In the context of the built environment, we do have tomorrow the commercial session, and then next week we also have the impact of COVID-19 on the construction sector and on the planning process. So thank you very much, and talk to you soon.
Thank you.